Deshmukh ma'am. I welcome Dr. Praveen Bhole sir, and I welcome Dr. Chaitanya Kunte as well, and all the participants again. And I would now like to request Dr. Kranti Deshmukh ma'am to have few words of welcome. Thank you. Over to you, Kranti ma'am.
Thank you, Pratik sir, and very good morning to all. It is indeed a pleasure and privilege to organize this unique 2 days National Symposium on Law and Music in association with Lalit Kala Kendra, Savitribai Phule Pune University. At the outset, I heartily welcome Chief Guest of today's program, Vidushi Arati Ankalikar Madam. Madam, your virtual presence for this program really made it special and memorable. On behalf of Shankarrao Chavan Law College, Pune and Lalit Kala Kendra of Savitribai Phule Pune University, I extend and convey my heartfelt thanks for sparing your valuable time and to inaugurate this 2 days National Symposium on Law and Music. We all are looking forward for your guidance and address at the inaugural session. Welcome, Madam, and thank you for being with us today. I also welcome Dr. Praveen Bhole, Head of the Department, Savitribai Phule Pune University. I also welcome participants of this National Symposium, teaching and non-teaching staff and students of Shankarrao Chavan Law College, Pune. At the outset, I would like to express my gratitude to the department Lalit Kala Kendra, Savitribai Phule Pune University for this beautiful collaboration. I am also thankful to Principal B.G. Jadhav sir, Executive President of Marathwada Mitra Manda Pune, for motivating us and granting all necessary permission for this symposium. I welcome one and all to this inaugural program. This is unique symposium having a blend of law and music. If you see, music is an art and law is having practical approach. When law and music comes together, a beautiful sculpture will come out, and we are expecting the true nature of this sculpture at the end of this 2 days National Symposium. So though we belong to law field, we believe in interdisciplinary studies and what is the connection of law and music. This is the object of our this 2 days National Symposium. We have many dignitaries present here for this program. Many dignitaries will be attending this 2 days National Symposium. I welcome one and all, and I extend my heartily thanks to everyone who have given their consent to attend this 2 days National Symposium. At the outset, briefly, I'll take this opportunity to introduce our institute to all guests and participants. Marathwada Mitra Mandal Shankarrao Chavan Law College is established in the year 2003. We have many programs running in the college, like 5 years integrated course, 3 years LLB course, BBA LLB course, postgraduate course, and we also have PhD Research Center affiliated to Savitribai Phule Pune University. Many passed out students of this institution, they are working in the capacity of judge, senior lawyers, and many are working in the corporate firm also. We are actually trying to break the traditional barriers of teaching methodology and trying to inculcate all necessary professional values which are required for law students. I'm very privileged and happy to inform you all that our law college is accredited with A grade by NAC in its very first cycle. So these are the few milestones which we have achieved during these 20 years. I am sure that all participants, they are eager to listen, ma'am, and we are actually looking forward this 2 days National Symposium and the various addresses, guidance which we will be receiving. So without taking much time, once again, I extend my warm welcome to one and all, and I request Pratik sir to move on with the program. Thank you so much for giving me an opportunity.
Thank you, Kranti ma'am. I would now like to request Dr. Praveen Bhole sir to have the welcome address. Over to you, sir.
Good morning, all. First of all, on behalf of Savitribai Phule Pune University and Lalit Kala Kendra and Pandit Bhimsen Joshi Abhyasan and Bharatiya Loka Kala Abhyas Samshodhan and Kalyan Kendra, I pay my tribute to great Pandit Birju Maharaj Ji. The loss is such immense. I welcome you all in this unique two-day symposium of law and music, which is jointly organized by Savitribai Phule Pune University's Lalit Kala Kendra and Marathwada Mitra Mandal's Shankarrao Chauhan Law College. As we all know, the Lalit Kala Kendra Gurukul is one of the university department of this Savitribai Phule Pune University, which has established in way back in 1988, and it is almost 33, 34 years from then now. And Lalit Kala Kendra is offering graduate, postgraduate, and research courses in performing arts like Indian classical music, Indian classical dance, and contemporary Marathi theatre. And from this current year, the center has started new unique 5-year integrated course, which have multiple exit points on the lines of new educational policy. Uh, and we have the results of this department as the alumni of Lalit Kala Kendra Gurukul of Savitribai Phule University are engaged in the whole entertainment industry, not only bounded in Maharashtra, but in India, and I can say without doubt in the world also. Uh, to create academicians is not only the aim and objective of this department, but to create uh, equally talented performers is also one of the major objective of this department. And just now, as Dr. Salgar has demonstrated as the example of Swami Vivekananda, so we know all the artists are primarily interested in doing the sadhana of their art, and they are totally engaged in the practicing their art only. So I think this is the very actually intelligent and unique idea to bring such two entities together, law and music, because there are many intricacies related to this field also. There are many legal phenomena and legal things that artists should consider. So I'm uh, certain that many insights will come out from this 2 days seminar, where the two paths, one path of music and another path of law, is intersecting each other. We will find many useful insights in this cross area. So I'm very optimistic, and I wish all the best for this seminar. I welcome all the dignitaries who are going to speak in this 2 days National Symposium. I also welcome all the participants, all the students of music, all the students of law, and all the Rasikas who have joined from all over the world for this 2 days seminar. Actually, we would have liked to have this seminar actually in university campus, and while discussing the legal terms, we should have listened some music along with it. But anyway, we have some benefits of online symposium also, so we will enjoy that benefits. I thank Dr. Salgar and Dr. Deshmukh for collaborating with Lalit Kala Kendra Gurukul of Savitribai Phule University. I wish all the best for this seminar. Dr. Chaitanya Kunte of this of our department is very instrumental in organizing this seminar. So I thank Dr. Kunte and Rohan Chinsore for organizing this seminar, and welcome again all of you.
Thank you, sir. Thank you for your kind words. And now we are having with us Vidushi Arati Ankalikar-Tikekar, and she needs no introduction, as because since many years she has been very instrumental in taking further this tradition of Indian classical music. And obviously she is having very stalwart gurus like Gana Saraswati Kishori Amonkar, Pandit Vasantrao Kulkarni, Dinkar Kaikeniji. So her gaiki is the blend of all the gharanas, and she has her own identity in the Indian classical music, in the field of Indian classical music. And today she will be talking about her some of the experiences at which she thought that there should be some kind of legal protection, and her experiences in overall Indian classical music, right from taking the lessons of Indian classical music until the today, and how the world is changing. And she is, I can say that, the witness of the earlier era and in the 21st century as well, what kind of the changes those has been occurred in this particular way. So I think she is the very perfect person for today's introductory speech and keynote speech for this particular symposium on law and music. So now I would like to request Vidushi Arati Ankalikar-Tikekar ji to please open this particular platform for the discussion by her keynote speech. Thank you. Over to you, Arati. Arati ji, you are please unmute yourself. Yeah, thank you.
Before I start, I'm really feeling very, very sad today because Pandit Ji's, Birju Maharaj Ji is not between us today. And मैं उनको मेरे तहे दिल से श्रद्धांजलि अर्पित करना चाहती हूँ. He was a great maestro. I got the opportunity of working with him for a bit. I sang a few compositions for one of his projects. ऐसे maestro थे. We have really lost a great maestro. और मेरी बिल्कुल दिल से श्रद्धांजलि. क्या कहूँ मैं उनके बारे में, सभी जानते हैं आज जो भी यहाँ हैं. To come back to the symposium, Shankarrao Chauhan College of Law and University of Pune Lalita Kala Kendra have arranged this symposium. I think it is a very good beginning in a way that the students of music should know more about law. In today's age, today's world, I feel every student must be educated enough to handle his own contracts, his whatever concerts he's doing, the contracts with the organizers. So I feel every student of music should be aware of his rights and laws. So I think that is the reason I congratulate you for arranging this symposium, firstly. Thank you, Kranti. Thank you, Dr. Bholeji, and thank you, Prateek. I would like to go back to my days, the earlier days when I started learning from my guru, when I was hardly maybe 11 or 12-year-old. And I didn't even know what law was. But the first time I was introduced to the word Kaide-Kanun was when I learned my first rag. Because there, my Guruji told me about lot of Kaide-Kanun to present the rag. So there are a lot of rules, the framework is so stringent. And I had to follow each rule, each kaida, each kanun properly. So that was my first introduction to the word. Later, when I heard the first tabla solo, I heard the word kaida again when the tabla player played the kaida. So what kaida meant there was there is a particular framework in which you can play the same bowls again, the different permutations, combinations of the same bowl. And there are some loopholes, of course. So if you compare law and rag, law and the kaida in tabla, I feel there are some stringent laws, some rules, strict rules, which you have to follow. And because of the rules, there is aesthetics in classical music, in the presentation of the rag. And just like law has loopholes, even the rag maneuvering has loopholes. So it depends on each artist's ability, creativity to look for those loopholes, and that is how you improvise and you present the rag. I think it's just like a lawyer does with a particular law. When he gets a case, and the way he studies his law, and he studies the loopholes, and then he makes sure that his client, is taken care of. And the same ways, the classical musician also looks at the rag. There are different rules, kaide, kanun, the way he has to deal with the rag, the ana, jana. And then in those rules, in that frame itself, he has to improvise. The artist improvises in the framework itself. But if he's creative enough, he gets to see those loopholes, and the beauty of the presentation increases. I think it's just like the lawyer's mind works. So the lawyer's mind and artist's mind is the same, I feel. So that is what I look at law and music together. So as I started learning, there were many kaidas, that is kaide kanun. I could not sing. I was a junior artist. I could not sing after a senior artist had performed. So that was a rule. Then when I started learning a particular gharana, I started with Agra Gwalior, and then I moved on to Kishori Tai, who was Jaipur gharana. Actually, in those days, changing the gharana was not the qaida. It was not the qaida. You could not do that. And which is right now, when I look back, when I look at it now, I feel that the qaida is right. Qaida is always right. That it said, do not change the gharana, because it changes the whole brain program, the way you think, the way you use your voice, the way, so if you say Sharir, Man, Buddhi, Atma, all the four things, whole the whole program changes if you change the gharana. So I think that Qaida was really good for me. So some of the, just like Bhole sir said, that, the kids are interested in sadhana. They want to practice, they want to learn from the guru, they want to, do the hard work, what is necessary. But I feel in the olden days, there was was invisible contract between the guru and the shishya of a 12-year contract of tapascharya. One tapa is 12 years. So learning from one guru for 12 years and doing that tapascharya was a contract in the olden days. So when I think of my early years of learning, all these thoughts come to my mind. And I feel that in today's world, as I said, the students should be aware of their rights, of some of the laws. But when I started in the beginning, I must have been what, like 14, 15-year-old? And just because my guru, Vasantrao Kulkarni, was a very popular person in his, group of people. So he always would arrange a lot of concerts for us, the students, and we would perform there. And just by mouth publicity, people started inviting me for the concerts. So there was no social media, there was no correspondence, there was no self-promotion, there was no marketing. Those were the days when only good singing, good presentation, good music was important, and that itself would market you. Suppose I sang well in one concert, a few organizers would be present at the concert and they would come to me and say, why don't you sing for this Punyatithi? Why don't you perform for that Jayanti? That's how I started getting concerts. I had no idea what a contract was. I never knew that I could ask for remuneration. I had no idea. I never demanded anything at all. I never even said, I don't remember saying that I want a particular tabla player, I want a particular accompanist. My remuneration would be this. I will travel only by, nothing of that sort. It was completely a one-sided invitation and contract. I was not there. I was just to go there and perform. That was the beginning of my career, wherein I would go to places. I remember going to all different cities in India without demanding anything. They were the most beautiful days of my life, wherein I was never worried about what I am getting. It was just the pleasure, the joy of music that took me to places. It was never because of any contract that I was going there. It was just because people were good listeners. They wanted to listen to good music, soulful music. And I wanted to present that music. I wanted to connect to people who were interested in listening to good music. That was a beautiful contract, wasn't it? A good musician and a good listener. What more can we ask for? Those were the beautiful days. Later on, when I was, I think, 20, that was the first time a music company contacted me and they wanted to record 2 albums of mine. And I think those were the days of telephones. So they called me on the telephone and they came to meet me. And they said that we have a contract for you. I was just doing my graduation. I had no idea what a contract was. And neither did I think of going to a lawyer and giving the contract to him to read or anything like that. I was so unaware. So, and neither did my parents think of it. I feel those were beautiful days when you don't think of these things. And so I was in a contract with the company. I did not know what I was getting. I didn't know whether I had to be in contract. They said that it's a 1-year contract. And they will do a few albums of mine. Later on, when a few months went by, they did record beautiful 2 albums in the beginning, and they were very, very successful. They sold really well. I did not know how to talk about the royalty. The contract was completely one-sided. It was completely one-sided. But I was happy because my music people heard, and it was one of the best sellers. And so I think I must have lost on the remuneration part. I must have lost in the royalty, but I gained a lot. I got a lot because they sold it well. It was one of the best sellers. So I think that way I got a fantastic break. So I have no complaints about losing on the royalty. And because in India, I can't even keep a track on the sales, on the royalty, on the percentage, and how much is the company selling, how much are they quoting to me, how much are they getting, how much are they paying me. All this we cannot track. And in those days, I could not track at all. At least today's age, maybe you have some tools by which you can do it. I am unaware still. But those days but as I said, I lost on something, but I gained something. So I was still, I was happy doing it. But I have seen artists in a contract. Those days, they would be in a contract with a company for 3 years. Company would just release 1 album, and which was not promoted well, which was not marketed well. So those artists were not seen in the market at all, in spite of recording with the companies. And later on, because they didn't sell well, the company did not record the artists again. And the artists were in a contract with the company, so they could not sing for other companies. So they were at a loss. And prime 3 years of their musical career, they lost because of this contract. So there are some unlucky musicians who had to go through all this. And some were fortunate like me, who got a lot out of that contract. And I think I was fortunate enough. Later on, when I started performing extensively, I remember I started going for foreign tours. And again, the word contract started coming in, because every time we traveled abroad, we had to enter a contract. And again, till today, I've seen every contract has been one-sided. It's high time, I think, all of us, all the musicians, all the companies come together and face the world together, united. I think it's really high time, I really feel. And when you think of law and music in India, there is only one music, that is Bollywood music, because it is such a huge industry, such a huge, humongous industry. The music of Bollywood is like thousands of crores, and whereas classical music hardly has any percentage in the music industry. So that is the reason I feel that the contracts, the law, the rights of classical musicians has not yet been considered at all. So that has been neglected completely because of the volume of the industry. And so when you say law and music, I think Bollywood music, it takes the biggest share in that music. But as I represent classical music, I'll talk only about classical music. So that way law has not yet, कानून के हाथ इतने भी लंबे नहीं हैं, classical music तक वो पहुंचा ही नहीं है. अब कानून के हाथ, so you know, classical musicians are just busy doing their kaide kanun of the rag only. They are so as I said, the foreign art concert started, and so many times I have heard a lot of stories of musicians telling me their experiences, that they entered into a contract with a foreign organization for a tour, but in the last moment, they could not get the visa and they could not travel, and they were denied the visa because the paperwork of the organization in the US was not proper. So it was not the artist's fault. It was the fault of the organization in the US, and the Indian artist lost the tour completely. He could not go for the tour. At the same time, he lost all the concerts that were offered to him in those next 2 months, because he was supposed to go for the tour. He refused all the organizers. So he lost on that tour as well, and also the Indian concerts. So who pays for all that? Who is responsible for that? Who takes the responsibility for that? I think there has to be a contract there too. So this is about the foreign concerts. Then came a time when I started getting written letters, proper letters of invitation. I would go for a concert and see a few cameras there. But I did not know whether to ask them, what is this happening? So without my knowledge, they started video recording the concerts. They started audio recording the concerts, which they did not have the right to. I remember when I used to go with Kishori Tai, my Guruji, for a concert, she would make sure 2-3 of her students would be in the auditorium looking for people whether they are recording the concert. And they would object to it and they would stop those people from recording. In spite of this, now we do hear hundreds of Thais concerts. They are there on YouTube today. So audio recording, video recording without the knowledge of the main artist and the accompanying artist was done in those days also. And there was nothing, there was no information or there was no permission asked for in the letter of invitation. So it was done without, we were not aware. Later on, the same thing continued. Sometimes then, later on, some of the organizations started paying for the video recording, but that is not in India, abroad. The next phase was when there was a big concert happening, and they would telecast it live on a channel, you know, some of the TV channels, and we were not even aware of it. And now today's age, when we go for a concert, it is again, they air it live on Facebook, YouTube, Insta, without even our permission. They don't even think that the permission of the artist is important. So from when I was 12 years old, without any letter, without my consideration, I was, of course, so those days, fortunately, there were no recordings, but I could not demand anything. And even today, after how many years? Like more than 45 years, we are in the same, artists are in the same position. Classical musicians are in the same position, I feel. So that is exactly the reason why I feel that all the students of music, classical music, should come together. They should be united. Because if one artist says, no problem, you know, you can, you do whatever with, you know, I want a concert, and you can do whatever with it. But then I think it affects every artist's life in some or the other way. So that's the reason all the artists have to be together in this fight, in a way, I feel. So all the music students, keep it in mind that you should know what a contract is, what you should expect, what should you demand. You have all the right to know how your work is going to be used while you're performing, even after your concerts. If some part of your work is going to be used later for their website, for some recording, for some movie, for some ad, whatever, all the rights have to be with the artists, the main artist and the accompanying artists. So I think that is very, very important. And also, you know, these days for any film song, if I've seen that there is a Copyright Act, and every music company that has recorded a particular film song, if that is sung, you have to get a permission to perform that song. But most of the compositions sung in classical music are termed as traditional. All the compositions, Piharwa Nahi Aaye. Now there is no copyright for Piharwa Nahi Aaye, because there are many Piharwas and many. So but I feel we have to consider the artist has to have the copyrights of his own compositions. And if they are sung, at least give the credit to the artist who has composed it. So it's not only about the traditional compositions, but and if even the traditional composition, if it is Sadharan's composition, if it is Adharan's composition, mention it. Why not? It's such a beautiful tradition of hundreds of years. Yaman was sung 400 years ago also, and it is sung today. The compositions of the Sadharan, Adharan were sung a few centuries ago, and even today. Why not mention their names? I think these are some of the points which I wanted to share with you. And also I would like to, the last point is, what about the cancellation of the concerts? The organizers never consider this at all. Because so many times what happens, I get an invitation from 2-3 different organizations. I accept one concert. And the other two, of course, I have to refuse because I cannot be at 3 places at one time. So what happens if the organizer cancels the concert which I have accepted? So there has to be some terms and conditions for the cancellation also. And most important thing, I feel, even the accompanying artists have right to the recording, audio recordings and video recordings. That also has to be taken into consideration. So these are some points I wanted to share with you. And I thank you all, Pratik, Kranti, and Bhole sir, Chaitanya, and for arranging this symposium and making me a part of this. And good luck to all of you. Thank you so much.
Thank you so much, Sai, for
so
sharing
much,
your journey right from taking the lessons from Kishori Tai until the date. And that will really help us to understand what kind of the legal things we should take into account from the artist's point of view. I was just wondering that you are having the background, legal background as well in your family, because your father-in-law was practicing in Bombay High Court.
Yes.
So I would like to hear something about him, and I think it will be injustice on the part of all the participants that if you don't sing the 2 lines for all of us. So I would like to request to sing few lines for all of us, and that will be I think the fantastic inauguration of a national symposium.
Oh, really? My father-in-law was a lawyer, and he was a great exponent of khayal, and also he was also a good composer. He had composed a few Sanskrit natya geets, and also a lot of bandishes, compositions. And those were the days, as I told you, that when I started my career, when I started performing, how beautiful the musical environment was. You will be really surprised to know that my father-in-law many a times told me that when he would appear for a case in the court, the judge would, when he would start his, case, the judge would say, Mr. Tikekar, yesterday I was there for your play, I came for your play. That Natya Sangeet which you sang was such a beautiful Natya Sangeet. And it was in Rag Jaijavanti, such a beautiful one. Can you please sing 2 lines? The judge would request my father-in-law to sing a few lines of that Natya Sangeet, and then he would say, okay, now proceed. So such beautiful days those were. I wish, those days come back. And we don't need any law, we don't need any contract, and we could just live freely and beautifully, isn't it? I think we, as a community, should work on this and should be law-free, rule-free, contract-free, but yet should be it should be so beautiful and taking taking into consideration each other, and I think we have to exist together. So, but I would like to, let me sing, Pratik. My God.
Yeah. We are eager to listen to.
Okay, I
Yeah.
Da. This is a composition taught by my father-in-law, who was a lawyer in Ahil Bhaira. Jago, jago re mai jago, jago, jago re mai jago, jago, jago re mai jago, jago, Ram naam so jago, jago, jago re mai jago. Jago, jago re mai jago, jago re mai jago, jago re mai jago, Ram naam so jago, jago re mai jago re mai jago re mai
Thank you so much. Thank you so much. I think that is not the just bandish, or those are not just the words that jago, jagori, mai jago, but that bandish wants all of us to get together and to start the real activism to connect both of these disciplines, law and music. And thank you so much again for coming virtually and joining us, and for gracing this particular occasion and opening this particular platform for discussion and sharing some of your experiences, so that we can understand and we can just imagine, as because you have witnessed all of these golden moments, but we are just trying to imagine that how that particular era was. And thank you so much again, Arati, for joining us, and thank you. Good day. And with this, we have came to an end of the inaugural function, and we will be shortly starting with the first session, that is by Dr. Keshavchaitanya Kunte, and he is with us. Just a minute.
Shall we start it, because we're already running late?
Yes, we will start with the session. So now we are having with us Dr. Keshavchaitanya Kunte, and again, he is a well-known harmonium player, musician, composer, bandishkar, and right now he is working as assistant professor of music at Lalit Kala Kendra Gurukul, Savitribai Phule Pune University. And again, he has got very stalwart gurus, Dr. Arvind Thatte, Pandit Mohan Rao Karve, Dr. Ashok Daranade. Also, he is Sangeet Alankar. Also, he is MA MPhil in the history and the archaeology. And if you read some of the articles which he has written in Lok Satta, you can understand he has his own perspective towards the music and its the social connections and the overall impacts on the culture of the civilizations. And he has got many awards as well for his research work. And so I think he's the perfect person for today's opening session that he will be talking on the Musicsprudence in Hindustani music. So I welcome Dr. Keshavchaitanya Kunte to this two-day national symposium on law and music. And now I would like to request you, sir, to start with the session. Thank you.
Thank you, Pratik. Actually, it is very difficult now for me. Artitai has made it difficult for me because after her very soulful singing, I'm going to talk in a way about a very sort of dry part, theoretical part about music and law. While discussing music and law, here I must clarify that I am restricting my scope to Hindustani music, that is North Indian classical music, usually known as Indian classical music. I'm a practitioner, music practitioner, and not a student of law. Hence, my point of view is strictly musical, though I'm taking the legal dimension into consideration. Dr. Ashok Daranade, one of my gurus, in his book Music Contexts, a concise dictionary of Hindustani music, in this book he has aptly stated that music is made in many ways under various circumstances and by different people. It has many modes of coming into being. Artists, accompanies, the common general audience, as well as the knowledgeable listeners, all have roles to play whether music is created. The entire endeavor is governed by unwritten but definite norms, even though we may not aware of them. So these unwritten and but definite norms are in a way laws in music, as also stated by Arati ji in the first session. Music is a performing art and it primarily uses sound as a medium of creation. Sound being an ethereal material compared to other concrete mediums used in other art forms such as painting, sculpture, literature, dance, and theater, music is more delicate and fluid in its nature. Hence, music has rules and regulations rather than laws. The Raga Sangita Shastra states a certain set of rules and regulations. If we consider them as laws in music, we must understand that these laws are not universal, but are subjective to change according to the time and space. With the changes in performance, the Shastra also have changed and culminated into diverse rules and regulations, with giving exceptions in the rules. Also, the performing world relies mostly on oral tradition rather than the scholastic or written tradition. Naturally, the laws in music are transmitted in the oral tradition with verbal instructions rather than written laws. The rules in Raga Sangeet are not rigid, but are loose or flexible. For example, every rule about rag formulation has certain kind of exemptions, like when the rule says that we should at least have 5 notes to create a rag, there are certain ragas which have 3 or 4 notes only. Or the general rule says that no rag can omit 2 consequent notes like rega or mapa. But there are certain ragas like Devaranjani or Adbhut Kalyan which overrule these regulations. The rules about Aroha of Raga quite often bended, seeking aesthetic liberty. Also, the rules about Raga elaboration or presentation of music forms and rules about gharanas are not strictly followed as laws. On the other hand, we find that master musicians who violated such rules to initiate aesthetic rapture have got a wider recognition as performers. Such violation of rules in music is legitimized by Shastrakaras, the theoreticians, as margantar. And of course, this margantar or violation of the rules or having a different marga way becomes later on a legitimate thing and becomes a rule later. So this process is ever evolving. There were several rules and regulations. Rather, I will say that etiquette suggestions mentioned in oral tradition and mentioned in performing world in the Hindustani music. For example, not to sing publicly until the guru or ustad permits, or never to sing after a senior musician, or to touch right earlobe like this while uttering the name of guru or while singing the song line in which there is a mention of a composer like mudra or chhap. Dr. Ranade again mentions that in Carnatic music, the performance, that is kacheri, is said to be traditionally governed by 5 sets of rules that control and determine the proceedings. The first is Gayaka Vadaka Dharma. Now here dharma means law. In Indian context, dharma is not just religion. Dharma also means law. So the first Gayaka Vadaka Dharma is rules pertaining to the ragatal form and behavior protocol of the artist and accompanists. Second set of laws is Sabhapati Dharma. Every gathering has 2 president personalities, one knowledgeable in music and other person respected in the society. They may intervene in the proceedings to ensure proper understanding of the music and the successful completion of the venture. The third set of rules is about Samaja Dharma. That is, the members of audience are to observe certain rules, such as keeping quiet, give response at proper time in a proper manner, or to go out or come in such a way that not to disturb the gathering, etc. The fourth set of rules is Yajamana Dharma. When a patron organizes a concert in his house, he should look after the artist in every way and pay them in a considered proper. The fifth set of rule is about Karyadarshi Dharma. That means an overall organizer has to ensure the proper sequence of the performance and provide necessary information about the artists, items, etc. from time to time. In the early 20th century, there are instances on the written contracts between Guru Shishyas. For example, Abdul Karim Khan Sahib or Pandit Vishnu Digambar Puliskar used to make a point in having a contract for at least 9 years with the disciples and their parents, because at that time there were cases like these gurus taught some student for say 4 or 5 years, and then that student just left without notice, giving a notice to the guru, and joined a theater company. And in that sense, these gurus or ustads were keen to have a contract, and if the contract was broken from the student side, the parents were supposed to repay all expenses the guru had done during the years of students grooming. So we can find such contracts also. Another important fact to mention in Indian Raga Sangeet, that is, Raga Sangeet is a process-oriented music rather than product-oriented music, unlike Western art music, in which a music composition becomes a sellable or a copyrightable commodity. Now, music is a commodity there because it is a product-oriented art. But in Indian music, it is not. It is a process-oriented form. So the process-oriented nature of Hindustani art music makes it rather difficult to handle it in reference to intellectual property or copyright issues. It was only when the recording industry came into India in British period, some 100 years ago, Hindustani music was thought in terms of a product. The artists started getting royalties and copyrights or the formal remuneration. The gradual process of almost a century about emergence of film music, then TV channels, social media, and now online platforms for music in India, the legalities about music have become too complicated. And that's why we have such kind of seminar here. In this 2-day symposium on law and music, we are going to discuss various aspects such as musicians' rights, copyrights, legal terms involved in music production, etc. But before taking the contemporary scenario into discussion, I'm going to bring forth some interesting facts about music, musicians, and legislation in ancient India. This historical review will make us aware about the past, rethink about the present, and define the strategies for the future. So let us know about the laws about performers or musicians in the ancient times. In ancient India, Sutra Granthas, we get several references to laws about performing communities. Sutra means a string and also a rule. Sutra Granthas are the books of rules or law books. As the term dharma signifies right, duty, and law, Dharma Sutra are the books of laws about rights and duties. They give rules and regulations about Varnashrama Dharma, that is caste and life phases, and it concerns economic life, governance, civil and criminal law. Dharma Shastra, that is ancient Indian law, mentions the laws about performers while discussing the social laws or civil law. But before going to these Dharma Shastras or the Dharma Sutra Granthas, I will just briefly have a look at Artha Shastra, Kautilya Artha Shastra, which was written in the 3rd century BC. The Artha Shastra, as the name explains, is a treatise on Artha. Kautilya has defined it in the concluding, that is 15th Adhikaran, namely the methods of science of his work. Kautilya says that the source of livelihood of men is Artha, or the earth inhabited by men. Artha Shastra is the science which is means of acquisition and protection of the earth. The aim of Artha Shastra is to teach the rulers how to acquire and protect the kingdom. And there is a very beautiful or very thoughtful paper by theater scholar M.L. Varad Pandey. The title is Performing Arts and Kautilya Arthashastra, in which he has given several facts about how Kautilya in Arthashastra mentions the rules about the performance. So I quote from him his paper. Kautilya has treated performing artists as any other class of the king's subjects and dispassionately discussed their duties and obligations towards the state. As a class, he does extend them few special privileges, limited state patronage, but at the same time, he's shrewd enough to extract taxes from them to enable the state for those occasional favors. He entrusts the duty of entertaining people to the lowermost class of society. Kushilava karma, the art of acting, singing, dancing, is their dharma or sacred duty. So the artists, the singers, dancers, instrumentalists, and actors, this class was called as Kushilava. And Kushilava karma means their sacred duty of performance. While giving layout of the fortified city, Kautilya says that a courtesan, that Rupa Jiva, the dancers, Talabachar, etc., should live in the southern quarter of the city or the south of the royal building. The implied meaning seems to be that they should live on the southern border of the city, because at another place he stated categorically the king must not allow the Bahirika, that is gamblers, beggars, actors, dancers, etc., to settle in the city, as they are harmful for Pura or Rashtra or Janapada.
लोक तुला accommodation म्हणतो ना.
If at all they are to be accommodated, they may be settled on the border of Janapada, and like other citizens, they may also be compelled to pay taxes to the king. In the chapter concerning the salaries of the state employees, Bhritya Bharananiyam, Kautilya says that the Kushilava, that is the artists, performers, should get 250 pana. Pana was currency at that time per year, but makers of instrumental music instruments, Turyakara, should get a double of the amount. So there are several such rules and regulations about the artists in Arthashastra. There is very interesting fact that this Kautilya also gives certain rules about Ganikas and the Kushilavas, or Nata, Nartaka, Gayaka, Vadaka, Vag Jivana, Palavaka, that means rope dancers, Saumika, the jugglers, and Charana, the bards. The state also extends protection to the class of performing artists in various ways. If a Kushilava or artist, small articles, probably his instruments or his makeup kit or a sort of a drapery is stolen, the thief would be given a fine of 100 panas. And if they happen to steal major articles like his property or something more valuable, the fine of 200 panas is prescribed. People are warned against doing verbal injury to actors and their art, or musicians and their art. They should be slandered in learning or art of Vagjivana, not they should indulge in making fun of the profession of Kushilava. So this kind of obligation was also mentioned, that the citizen should not verbally injure or insult the artists. The tax is the basis of state treasury, and Kautilya knows for certain the importance of taxes. We have earlier seen that though the dancers, actors, and musicians were given a place to live just on the boundary of the village, Kautilya treated them on par with the other classes of citizens as taxpayers. The performing artists were required to pay tax to the king from their earnings. The tax collected from artists was called as Durga. Kautilya says at difficult times, to fill the royal treasury, half of the income of the Rupa Jiva, the prostitutes, and the Kushilavas, musicians and actors, should be taken away for the state tax. Kautilya also imposes entertainment tax on the shows. He says that the company of performing artists from foreign country performing in the state should pay entertainment tax, Preksha Vetana, of 5 panas per show. Now here I remember that when we musicians go to USA or any other country, we need to have a permission of the state and the music academy or the musicians council in that country for our performance. Now this is very similar practice in ancient India, that the foreign performers were supposed to pay entertainment tax per show. He has allowed the actors and musicians, that is Kushilava, to perform at any place in the country and entertain the people, but they must avoid making fun of the country, that is Desha, caste, that is Jati, family, that is Gotra, and a certain school of Vedic study, the Charana, and copulation of men with women. So the actors and musicians should not make fun or comment on these points while their performance. This was the rule. Today's scenario is very different in this manner. The Kautilya also deals with various subtopics such as non-payment of debt, concerning deposit, law concerning slaves and laborers, undertaking in partnership, that is Sambhuya Samuthan. And here I am indebted to Dr. Anagha Joshi, a Sanskrit scholar and a professor at Sanskrit department in our university, because she has generously given me valuable information about Sambhuya Samuthan and the laws about musicians. And I recommend the law students to read her book, Sambhuya Samuthan in Ancient India. It's a very valuable book about the rules about corporate in ancient India. It's a very important book. So I quote some part from Dr. Anagha Joshi's book. Sambhuya Samuthan is a general rule of any cooperative enterprise. And Smruti literature states that where merchants do merchandise, priests sacrifice, farmers do farming, or artisans do craft, or actors and musicians do acting and dancing and music making, the thieves do theft. By coming together, that collective work is known as Sambhuya Samutthana. As it literally means, by this they prosper collectively. Sambhuya Samutthana. So in the light of Sambhuya Samutthana, there are several rules and regulation or laws about performing artists. And in Kautilya Arthashastra also there is mention of Sambhuya Samutthana, and he mentions Karu Shilpa Kushilaba Chikitsaka Vagjivakana Paricharika Dira Dira Karika Vargastu Yathanyastad Dvidaha Kuryat Yatha Va Kushalaha Kalpeyastutha Vetanam Labhet. That means the group of artisans, artists, musicians, minstrels, physicians, professional storytellers, attendants, and others who work in hope of remuneration should get the wages similar to others of their class, or remuneration as per the fixation by the experts, Kushalaha. And he further states that failure to pay the wages or the remuneration shall be punished with a fine of 10 times of the amount of the wages, Dasha Bandha, or 6 panas. Misappropriation of wages shall be punished with a fine of 12 panas, or of 5 times of the amount of the wages. So such kind of law was there. And as Arati mentioned, what if the concert is cancelled, and what about the remuneration? So in Arthashastra such rules were given. Now let us look at Manusmriti. Manusmriti, a social law book during around 1st century BC, gives several laws related to musicians and artists. Manusmriti, taking a doubt on them as criminals or antisocial, states that artists or musicians have no right to appear as a witness in a court case. It's very interesting to know that. Also, Manu is very harsh about certain things of being musician. He stated that the Brahmin who are professional musicians are not considered eligible for Pitru Karma. Also, he mentioned that the student or Brahmachari has to avoid certain things, and in that long list of the things to avoid by the Brahmachari, he mentions music, like singing, playing instruments, and dancing. Also, he mentions music in the list of 10 vices. But the Yajnavalkya Smriti is very thoughtful about certain laws. After Manu, the most eminent lawgiver is Yajnavalkya. The period of Yajnavalkya Smriti is 1st century to 3rd century AD. Yajnavalkya Smriti belonged to the Shukla Yajurveda, and Yajnavalkya views are more modern and more advanced than Manu. The arrangement of subject matter is more concise, clear, and systematic. The contents of the work are divided into 3 heads: customs, that is achara; law, that is vyavahara; and expiations, that is prayashchitta. In the second division, namely vyavahara adhyaya, Yajnavalkya gives us titles of law. They are civil laws, recovery of debts, deposits, witnesses, non-payment of wages, concern among partners, theft, etc. And Sambhuya Samutthana is one of these laws. And Yajnavalkya mentions that samavayana vanijam labhartha karma kurvatam labha labho yatha dravyam yathava samvida kruto. That means when a number of traders or merchants and also the artisans, actors, musicians come together for carrying on a trade of enterprise for making profit, they shall share the profit or loss according to their respective shares or according to the agreement which has taken place among themselves. So it is very clearly mentioned about the share of profit and loss. It is a general rule of any cooperative enterprise. So the commentator in Vivada Ratnakar is also say that yatha dravyam samavayana yena tena swaswa dravyanusare yathava sarmavida samavayena. That means in the absence of an agreement, the shareholder shall receive the profit or bear loss according to their respective share in the stock. That is the work they have done. Where an agreement exists, the business shall be carried on the basis of the agreement. So it is very clear in the Yajnavalkya Smriti. If we look into Narada Smriti, again, it is very clear. Narada is generally looked upon as a lawgiver of advanced views and theories, as he is later than Manu and even Yajnavalkya. The period of Yajnavalkya Smriti is around 4th century AD. Here Narada states that Pratigraho Dvijatinam Dhanam Rangopajivanam Skandhavahyam cha yad dravyam na taduktam pradapayat. That means apart from the household articles, some other articles are also exempted from duty or tax. The alms received by a Brahmin, the property of Rangopajivin, that is actors, singers, musicians, dancers, who earn their livelihood through the stage performances and whatever that is capable of being carried on one's shoulder, that kind of such small property, all this should not be taxed, or it should be free from any kind of taxes. So from Arthashastra to Narada, we find that there is a progress. Kautilya has imposed harsh taxes on musicians, but here Narada Smriti says that the musicians or the performers who live with stage performances should not be taxed. To comment upon this verse, Asahaya Bhashya states that Brahmana, performing artists, and the ordinary people should not pay taxes to the king. It's very interesting to know this. Then Brihaspati Samhita or Brihaspati Smriti. Brihaspati is one of the prominent ancient lawgivers, was probably one of the first jurists to make a clear distinction between civil and criminal law. According to P.V. Kane, the period of Brihaspati Smriti is from 300 AD to 500 AD. Brihaspati states that the remuneration or profit of artisans and artists should be like Hema Karadayo Yatra Shilpim Sambhuya Kurvate Karmanurupam Nirvesham Labheranste Yatham Shataha. That means when a goldsmith or the artists or the performers practice their art jointly, they shall share the profit in due proportion corresponding to the nature of their work. This is the basic principle of cooperative enterprise or joint venture. From the Jaimiya Purva Mimamsa Sutra, this rule has been ordained by all Smritikaras. When people come together and start a new enterprise according to the nature of their work, the share should be distributed among them. And naturally, in this case, we know that in the ancient times there were guilds of musicians, like Gandharva Gana. There is mention of several ganas or guilds of Gandharvas. That means professional musicians. Gandharva, there are two types of Gandharvas mentioned in ancient India. The Divya Gandharva or Deva Gandharva, that were celestial Gandharvas. And second group was Manushi Gandharva. That means Manushi Gandharvas were the performers and entertainers. And such Gandharva Ganas, that means musicians guild, were there in ancient times. In Vedic literature, there are several mentions, like there were some 11 musicians guilds, or some give more number. But that means when there are such rules about the cooperative enterprise, and such rules were also followed for the musicians guilds, and naturally the distribution of remuneration or such laws were applied also for the musicians in ancient times. When people come together and start a new enterprise, according to the nature of their work, the share should be distributed among them. The same rule has been obtained in the case of musicians and dancers. Brihaspati says, Nartaka namesha eva dharmaha sadbhirutata taladnyo labhate ardhadya gayanastu samavshinaha. That means the same rule has declared by virtuous men for musicians and dancers who know the rhythm. Taladnya shall take the share of a half, and the singer should have the equal share. Now here I remember that even before, say, 100 years, such kind of share was decided. Like in autobiography or biography of Keshavchaitanya and Hirabai Bodekar, it is mentioned that when Keshavchaitanya used to get a certain remuneration, 50% of that remuneration was hers, and the 50% was distributed among her co-artists, that is accompanies. And in that proportion, in that 50% share for the co-artist, 20% was given to the tabla player, and then 15% each was given to sarangi player and the harmonium player. In the case there were 3 accompanies, and if there were only 2 accompanies, like tabla player and sarangi player or harmonium player, it was equally distributed, like 55% for each co-artist. Even it is mentioned in biography of Master Krishna Rapulambrikar about such distribution of the remuneration. So these were certain norms or laws about the distribution of the profit. Of course, there is no mention of a distribution of if you have loss, how to bear the loss. Of course, there are certain, I must say that the rules were not written down, but they were like verbal contracts. Now let us see what Katyayana Smriti says. Katyayana Smriti, written around 4th century to 6th century AD, states the equal distribution of profit or gains among the joint artisans, artists, merchants. Samave tastu ye kechit shilpino vanijo apiva. Shilpi means the artist, including musicians and dancers. Avibhajya pruthar bhutaihi praptam tatram phalam samam. That means those traders, merchants, artisans, and artists who jointly carry on business shall share the profit equally. Further, Katyayana states a rule for artisans. It reads as follows: Shikshaka abhidnya kushala acharya cheti shilpinah ekadvishtri chaturbhagam hareyuste yathottaram. That means the artisans, namely a young apprentice, that is Shikshaka, experienced scholar, that is Abhidnya, good artist, Kushala, and a teacher, Acharya. If they work together or be jointly employed, they shall receive 1, 2, 3, or 4 shares of the pay or profit respectively. That means Shikshaka was given 1 share, Abhidnya, the men of experience, learned or experienced people, they were given 2 shares, Kushalaha, they were 3, and Acharya, the teacher, 4 shares. So such kind of distribution of the profit was done. Now, I'm going to conclude with an interesting story about a lawsuit in a modern period. Yeah, here I must mention that though we get such laws in the ancient times, in the Smriti Granthas or Dharma Sutras, the text on music or musicology are completely silent about such things. Of course, it is natural because the musicological texts like Bharatanaट्य Shastra or Brihadeshi or Sangeeta Ratnakar, they were Tattva Granthas or Lakshya Granthas. That means they were talking about the Tattva or principles of music making and not about the social or judicial setup of music or musicians. Naturally, we don't get a single word about such rules about the musicians or musicians community as such, social laws. And these laws were only mentioned in Dharma Sutra Granthas. So if we want to study the whole picture of the existence of music and musicians in ancient times, we need to study non-musicological texts also. And in this case, we should read Dharma Sutras or texts like Kautilya Arthashastra and many others. Without reading such material, our perception will not be clear about the ancient times. Unfortunately, when we enter into the medieval phase of Indian music, we don't find much literary references to such laws, because the social organization was changed and it was very different than the ancient times. And we find that in medieval times, mostly the royal patronage worked in a different manner. We get to know about several cases of royal patronage, and especially in the Mughal courts, there are documents about the remunerations of the musicians, like which musician was paid what kind of amount in the royal court of Mughals. Or even in Maharashtra, such documents appear in the Peshwa Daftar or the documents or archives of the various Sardars like Shinde, Gaikwad, Holkar, etc. And that carries on in the British period also, like when the princely states were there, we find documents about what kind of payments were done to the musicians. But we don't know about the legislative side of that, because this kind of patronage was just like these kings or rich person were patronizing the music. It was not wages or employment as such. Yes, there were employments of certain musicians as court musicians, and they were given certain wages, certain properties, or even like a piece of land or hathi ki sawari sort of privileges also. But there is no fixed structure or law about such patronage. At least I am unaware of such laws. And as the social organization was different, like in medieval times, there are several communities like Kalavanta, Bhand, Natwa, Bhadwa, then like Tawaiffs were there. Then Dhadi and Mirashi was a very important class of musicians. And each class, there were certain rules and regulations, or we can say social laws about the community. These were the laws inside the community. And for each community, these laws were different. And these laws were followed until, we can say, the 20th century, or independence, India's independence. And after India's independence, that kind of laws were replaced by our Indian Penal Code. And naturally, that's whole social organization and laws about musicians no more exist. Of course, certain laws are followed to even today in a oral tradition, but not in formalized way. And of course, musicians in today, they don't belong to the traditional communities. Like hardly, I think there are musicians who belong to the traditional communities of Dhadis, Mirasis, etc. Because in last century, the social fabric of musicians was changed, and non-traditional families, the members of non-traditional families of musicians enter into the music industry. And then this social fabric changed, the laws and the perception of duties and do's and don'ts and the legislative structure changed in music. And that's why we don't find that the medieval laws about music making and laws about musicians are prevalent today. And naturally, we follow whatever our Indian Penal Code states. So today, the laws about musicians are just like the laws about general citizens of India. There are no special laws about the performers as they were in ancient and medieval times. So now the scene has changed grossly. Okay, so I'm now going to conclude my presentation with an interesting anecdote. Though we can find such anecdotes in history of music, especially in modern period, there are thousands of such anecdotes. But I'm going to mention one of that. And I must mention here that there were certain personalities in Hindustani music related to law. And the most famous personality was Pandit Vishnunarayan Bhatkhande. As we know, he was a lawyer and very successful lawyer. There are some personalities related to music who actually are lawyers or related to law field, like Pandit Ravi Shankar's father, who was a magistrate and a very successful lawyer at that time, and he worked in London as a lawyer at that time. Or as mentioned by Arati ji, her father-in-law Vaishampayan was a successful lawyer. Or Baburao Joshi, a very important contributor to modern Maharashtra's music, was a lawyer. And always it is mentioned like Baburao Joshi Vakil. And he has written extensively on music, and his work is highly acclaimed work, especially about music appreciation, about theater music in Maharashtra, etc. So he was a lawyer who contributed immensely in Hindustani art music. Also, we find there were certain musicians like Bhaskar Bua Bakhle's one disciple was Pitre Vakil. He was a lawyer, but also a singer. Even there is a mention of Kale Vakil, again a lawyer who used to sing. So there are many such personalities in last century who were lawyers and also into music. And I remember that there are two persons who never pursued law as lawyers, but they took the degree in law. First is Dr. Prabhatre, and second is Dr. Ashok Dharanade. Both had their formal education in law. They attained the degrees of law, but they never stepped into the court as lawyers. But I must say that we can find the analytical approach or a very clear framework of mind while analyzing the music in both Dr. Ranade and Dr. Prabhatre's work. Because I think the framework of law gives you a different kind of perspective to look, to analyze, and to conceive the musical thought. And that is why I think it's very important. And the same applies to the work of Pandit Bhatkhande. Being a lawyer, his views were so clear that he has reconstructed the theory of modern Indian music in a such a way that hardly it cannot be challenged. Now, let us sum up this with a very interesting anecdote about a lawsuit. And here I actually quote from Rajan Parikar's website. Actually, that anecdote is mentioned in Professor B.R. Devdar's book, Thor Sangeetkar, and also translated in English, Pillars of Hindustani Music. Have you heard of a court case in which a shagird, a former disciple, sues the ustad for refund of fees paid by him or her at the time of the Ganda Bandhan ceremony? This is what happened in case of Khan Sahib Rajab Ali Khan. The interesting feature of this case was that the counsel of the defendant was none other than late Pandit Vishnu Narayan Bhatkhande. Rajab Ali Khan, in his young age, was appointed as ustad by a famous singer or a courtesan for tutoring her niece. And this singer was staying at near Kennedy Bridge area in Mumbai around 1888 to 1910, that period. We are talking about some 100 years back. The Ganda Bandhan ceremony was done with payment of rupees 1,500 as nazar to Rajab Ali Khan Sahib. At that time, it was a custom to pay nazar, that is a fees during Ganda Bandhan. That was not a formal fees, but it was like a gift to the master. Rajab Ali Khan was a court singer of Dewas state. Dewas state is a princely state in Madhya Pradesh, and we know that Dewas because later on Pandit Kumar Gandhara settled down there. But Dewas was a important seat of music, being a princely state at that time. So Rajab Ali Khan Sahib was a court musician at Dewas, and he used to have frequent visits to Dewas on Maharaja's demand. When returned to Bombay after such a visit, he received a notice from the singer's lawyer stating that he should return the amount of rupees 1,500 as he hadn't teach the niece not a single lesson. Elsewise, he was threatened to have a court case. And Rajab Ali Khan Sahib, being a naive person in such matters, took Pandit Bhatkhande's advice. Bhatkhande agreed to fight the case on Khan Sahib's behalf. And when the matter came up in the court, Pandit Vishnu Narayan Bhatkhande argued that the payment made at the Ganda Bandhan ceremony, being Guru Dakshina, that is the nature of gift to the Guru, the disciple can in no circumstances ask for its repayment. And the court, accepting this reasoning, decided Khan Sahib's favor. So there are such very interesting lawsuits in music field also. The famous court case of Gohar Jan and about her property is a very interesting to study, and I think that is also mentioned in some law book. So here I conclude my session, and I hope that the further sessions today and tomorrow will be very enlightening to us as musicians, and of course for the students of law. Thank you.
Thank you. Thank you, Dr. Chaitanya Kunte sir, for throwing the light on the various historical approaches, right from the Kautilya's Arthashastra and Brihaspati Samhita, and giving some of the examples of the lawsuits of the various music patterns, so that the music, the students from the music, and as well as from the legal fraternity, they can understand the scenario in right way. Okay. So thank you so much, Kunte sir, for joining us together to this virtual session today, and for sparing your valuable time. And I'm sure that whatever views and the opinions which you have shared with us, that will be very enlightening to all the participants from the legal and the music fraternity. Thank you so much again. Yeah. So now I will be sharing the feedback link for the Chaitanya Kunte sir's session in the chat box. So please fill up that particular feedback form. And now we are moving to the next session, that is by Mr. Rajendra Vaishampayan. So, firstly, as a part of the introduction of Mr. Rajendra Vaishampayan, he holds the patent for the structural change in the traditional harmonium. That is, I think, a very unique kind of a thing about Mr. Rajendra Vaishampayan. So, it is the thing that he will be knowing all the legal formalities and all the legal aspects as to the patent. And he is very dynamic personality, as because he is having various we can say that the qualities, like he's a tabla player, and he had very stalwart people again as the gurus, like Ustad Allar Khan Taleogi Pandit Suresh Talwalkarji. He's also the harmonium player, and his guru for the harmonium is Pandit Manohar Chimote. And apart from the musical background, he is a software engineer, and he has started working as the software programmer in the IT field. And uh, he's also the recording engineer as well, and he engineered more than 1,000 projects as the recording and the mixing engineer. He's also the composer, arranger, and he composed 5 albums and arranged songs for more than 10 albums. He is the founder, chairman, and the managing director of the Sonic Octaves Private Limited. And that's why the topic for the today's session, that the nexus between the law and the music and entrepreneurs' perspective, he is a very apt personality for throwing the light on the various aspects as to the nexus between the law and the music from the entrepreneur's perspective, as because he is himself the entrepreneur of a company named Sonic Octaves Private Limited. He has also ventured into the merchandising and branding of the Indian classical music as well, which is the need of a time in today's era. And one more very unique feature about Mr. Rajendra Vaishampayan is he has created a trust by the name Association for Integrating International Contemporary Arts and Artists. So this particular association or this particular trust, he is the managing trustee of this particular association, and this particular trust works for the artist career counseling, free website development of the artists. And I think these are some of the important features which we should take into account as far as working and functioning of this trust is concerned. So now I would like to request Mr. Rajendra Vaishampayan to start with his presentation. And the topic for his presentation is nexus between the law and music and entrepreneur's perspective. Over to you, Rajendra sir.
Yes. Thank you so much. Am I audible well?
Yes, sir. You are
Okay.
audible. You are
Okay,
audible.
great. First of all, my deep respects and Shraddhanjali to Pandit Birju Maharaj. There are certain personalities who change the way you look at life. And for me, Birju Maharaj was one of them, because I never had a insight into how to appreciate dance when I started and when I was in college. But I attended one of the concerts with Birju Maharaj with Zakir Bhai, and that was one of the, I would say, a turning point for me to appreciate and understand how the dance is actually appreciated and how it should be watched basically. So today I remember that experience as the sad demise of Maharajji. We're all very, you know, we have the grief about it. Coming back to why we are here today, I would really like to thank Shankar Rao Chauhan Law College, Lalit Kala Kendra, Dr. Keshavchaitanya Kunte, were a dear friend of mine, uh, Dr. Pratik Salgar, who's a coordinator and doing his job so well that it's, he makes you really comfortable and the communication is extraordinary. So thanks to you, Dr. Gore sir, and all the dignitaries in this August gathering and all the participants. I know that some of the participants include organizers, lawyers, law students, and music lovers, and some of the artists also. So I'm aware that I need to be very careful with my words today because every word is being watched, so to say, and especially in the group of lawyers, you have to be very very careful. So I'll make sure that uh, I speak truth and just the truth, and I speak my heart out here. So let me share my presentation. Just a second. It is asking me to. Okay. Is this visible? Okay, just a second.
Not yet, sir. It's not visible.
Okay. It's visible now?
Yes, sir. It's visible now. It's
Okay,
visible.
super,
Thank you.
super. So let me first of all, because as I said, I'm in the August company of lawyers and the law students. As an aware person, let me start with a disclaimer that all the views expressed here are based on my observations and experience as both the musician and also the founder CEO of an art media entertainment company, which is as Pratik ji mentioned, Sonic Octaves Private Limited, which I started about 14 years ago. Another disclaimer is there are many aspects of this subject which would be touched upon, and they're at a very superficial level because there are so many aspects and there are so many branches and sub branches to that subject that it is very difficult to cover that up in interest of time. But I'll touch upon some of the important aspect that I realized as the musician and as an entrepreneur, especially working in the field of art, media, and entertainment. And I must say some of the views that I may express or I would express may upset a few and inspire many, but I'm very positive that it would make people think about the industry and its players and their roles and responsibilities, especially considering that there are so many players with variety of interests that those are coming together. So so with that, let me just move on. Let's talk about law. And from my perspective, I'm not the student of law, but the way I see it is, it's basically, and some of the dignitaries in the earlier sessions have actually mentioned it, that it's basically a set of or the framework of rules. That's what, in my opinion, what law is. I may be oversimplifying it, but I think for the layman's or for the person who is not really well versed with the legal structures or laws or all the sections and everything, for me law is set of rules or a framework of rules where everyone involved or all the stakeholders, as they say, they have to come together, and the expectation is to be fair. I have underlined, highlighted, bold, made the word very bold. is expectation is to be fair with everyone involved, and that needs to happen within the framework of those set of rules or the framework. So the essence here of law is, or its main purpose, as we say, is to provide the justice. So when I say justice, it has to be, as I said, fair and equitable, and it should consider all the participants and the shareholders which are involved in the whole process of music creation, distribution, presentation, consumption, and it's all its financial and legal aspects of it. So that's for me, as an entrepreneur also and as an artist also, is the essence, that it should be fair, and those set of rules should be first of all understood and accepted by all the people involved in the whole ecology of music, and its overall framework of presentation. So incorporating that framework, in the and the fairness and the justice in the business transactions, is good legal and moral business. So when I say business, first of all, there is for some reason, there are, when you talk about business, it has some taboo, or it has some, very exploitation, quote unquote, kind of a flavor. When you start saying, okay, I'm in music business, then some of the people involved think, and probably with their experiences, uh, business people don't know nothing about music, and so they are there to exploit musicians, and so on and so forth. So in my opinion, uh, the law and the set of rules and the overall framework comes into picture, just to make sure that we have a good legal and the moral uh, business framework for all the people to act within, or to collaborate within that framework. And that, for me, uh, law is restricted in that kind of sense, or it is the essence that we all should be bound by. Next, let's talk a little about the artist perspective, and this is especially, uh, there is some background happening, uh, especially Indian classical music scenario. And as Artitai mentioned in her speech, it is a very, very minuscule percentage of the overall music industry in India. Uh, Especially, I have worked with many artists as entrepreneur and as the producer of their music, especially the Indian classical musicians, and those who are exceptionally good in their art, but need some kind of a support and need some kind of help in promoting their music to the right audience. And I have worked in that space, and I do work in that space still. And some of the interactions with those artists and my observations, as I mentioned, led me to some of these points which I'm going to mention. Is, for the artist, art is a divine blessing, and it is. And like with any other subject, every good subject, or every good presentation or representation, is a divine experience, so to say. It is not restricted to music only, in my opinion. But generally artists think that, अरे वो सब भगवान की देन है, and it is just directly taken from the heavenly abode directly into the heads of music. And that one way it is true. And so, it cannot be valued in terms of money. It is really shraddha and this whole spiritualism around it. And I do appreciate and acknowledge that it is true to a large degree. But at the same time, it is also important that artists live in this world where transaction is the way of life, right? And so they have to accept that some of the rules which are applicable to the standard normal operations in day-to-day life also applies to them. Somehow I have seen that artists feel that they are the chosen ones, and they are the special ones, and not all the rules of the game are actually applicable to them, and they are above transactions, and they're above something. Again, I do understand, and being a musician, I know where the artists come from, but I think the artists need to make that distinction between the art and the business of art, or the art and the commercials of art, or the art and the legal aspect of art. And if you don't make that distinction, that is where the confusion and having somebody talking in the background, if you can mute them. So it is true that artists in a way are chosen ones, but they also need to recognize that they are also supposed to be bound by the framework and the set of rules to be fair with the people that they are going to work with. Okay. Third observation that I have seen is it is bad to talk about business. As Artita mentioned, sometimes say organizers call you, or the record label companies call you, or people who organize the home concerts, or whoever calls you, then basically they feel that talking about money, talking about art, talking about the remuneration, talking about the constraints and the rules and the expectations that artist has in order to present his art, it is bad to talk about it, because then it will be considered as rude. Especially, I have seen a lot of the artists sharing with me that if they say that, if they mentioned about any remuneration or any conditions or terms to the organizers or the producers, especially in India, they are considered to be rude. They are considered to be, अरे उसको क्या समझता है अपने आप को, ऐसे कोई बात करता है क्या? We are offering the opportunity for him to perform, and हम उसको chance दे. ये chance देना एक जो बड़ी बात है in this industry is basically a very interesting model that has been happening since last so many years. That if you talk about, if a good but not so known artist or a upcoming artist talks about his remuneration or his terms or conditions, he is given this big cross, and then it's talked about in that small community of organizers. And anyway, the world is very small for Indian classical artists, and if they say that, okay, these are my conditions, then the organizer, अरे खुद को क्या समझता है, and then they will also mention this to the other organizers, saying ये बंदा है ना, वो बहुत रूड है, जरा सोच समझ के उसका प्रोग्राम रखना. So this is one of the reasons why artists shy away from mentioning or quoting or dictating their terms in a way, because they know that if they start doing that, they will be actually thrown out of this whole ecology of organization of concerts, and going around and touring and so on and so forth. So that is on artist's part, it is a fact for now. And it is also true that many of the artists have experienced this, and so they basically say, छोड़ो यार, उससे बदले हमें परफॉर्म करने मिल रहा है, we are हमें प्रेजेंट करने मिल रहा है, तो then let me just accept and understand and just go with whatever the organizer says, which includes the remuneration, which includes the recording part, which includes all the things, as Artita said in her presentation, that it is almost all the time one-sided, which artists generally has to accept because of this very small community, and with the understanding that artist is not supposed to say out when they are kind of upcoming. So that is one thing I think it's very strong from the artist perspective. uh, very interesting part about when I talk to artists is I generally have these two different aspects of any profession, as I mentioned, is the why part and the how part. When I say why part and the how part is, there are certain reasons, and there are certain driving forces which leads a professional to do his profession, because he wants to do it for a specific reason, and that is the why part of it. But only having the why part is not sufficient. He also has to make sure how he's going to sustain and survive and thrive, and that is the how part of doing a business or doing your profession. So in my opinion, artists are very clear about why they are why they are musicians or why they are artists, but I think they have a very less, they have given less thought about how they are going to sustain as artists, how they are going to make money enough to sustain and to help them do their why part. And because of that, there is, as I know, I also come from the software industry, we have a very specific uh, uh, career path where, after 2 years I'll do this, after 4 years I'll do this, after 6 years I'll do this, after 10 years I'll do this, and I'll be here and I'll be at such and such post, and so on and so forth. But it is very difficult for the artist to actually have that chart, because there is no precedence or there is no such framework exist. And secondly, if they are to if they were to try something different, then they do not have that ecology to even try out few things. So they have to go ahead with a very traditional way of growing, is ha aap karte raho, riyaz karte raho, and then things will follow. That hardly gives any career path or any direction to the artist who is already confused, who's already has a lot of questions about how he or she would further his art and make a living out of it, and establish himself as an artist. So all these things actually come into picture. And um, interestingly enough, when I start talking with the artists about the how part, most of them really do not have the idea about how they are going to manage their career as an artist. And very few people talk about it in their grooming period or in their training period, so that they are not really prepared when they are ready musically. In my opinion, they are not ready as a professionals, because they have not thought about, and they have not practiced, and they have not they're not trained for other sides or the other aspects of musicianship, like communication skills, negotiation skills, networking skills, and so on and so forth. And that's where a lot of challenges start happening. And as I said, talking about business, talking about conditions, talking about commercials, talking about contracts is considered rude. And so artists who talk about commercials, who talk about business, are considered, first of all, not good artists, or if they're good artists, then they're good artists. So those are the some of the things that we really need to ensure that artist understands it, and takes some steps, has some counseling, talk to people who can kind of guide them. And some of the counseling that I do with the artists who are upcoming are asking them some of these hard questions, and make them think about whether they have thought about all these aspects, and if they have not, at least guide them to consider their situation, their circumstances, and how they can find such opportunities to explore them from the soft skill perspective. Now let's talk about business. As I mentioned, uh, artists nowadays, they are, especially in the digital era, are entrepreneurs by themselves, because now with digital era, you are not only can or should focus on the music or the art, but they have to actually focus on all the other soft skills that I just mentioned. About the communication skills, they have to manage their accounts, they have to do networking, they have to manage their social media, they have to manage their advertising, they have to networking. Once they get the concert, then talk about the contract, the remuneration, and so on and so forth, right? And especially with the internet age today, the whole business model of music industry has changed. Because earlier, the way things used to work is, an artist gets noticed by the A&R person, artist and repertoire, through local gigs, or as again as Artiji mentioned, that you sing in a Jayanti or a Punyatithi, and that is where you get spotted. And the music companies will approach the artist, they will record them. And then the traditional business model is, music companies will record the artist, they will produce the records, they will give it to the wholesaler will give it to the retailer will then make it as it will he will display it in the shelf. And then the audience will notice the new recording or the new music, and then they will try it out, and if they like it, then they will go for another album. So this used to be a business model since the start of the recording industry. Of course, overall from the artist perspective, the remuneration from the recording or the royalties and so on and so forth, if at all they get it, is very minuscule compared to the royal or the remuneration that they may get from the live performances. But it's still proved to be a very important marketing and the promotional tool, the recordings. But with the advent of internet, with the internet era, now all these middle people who were responsible for furthering the business of music are all gone, right? The wholesalers are gone, the retailers are gone. Even the music companies, you don't need any music company to record you, because now you have YouTube, you have Instagram, you have so many social platforms that you can just record things, produce your music, produce things at home, and then you can get to YouTube and be known to your fans immediately without really having any obstacles or these agents, so to say, in between. The bad side or the downside of it is that now artists with all the access to good technology and good social platforms are not really careful about producing a good content. They just sit in a hall, they just start their mobile, they just start recording and put it on the YouTube. So all the seriousness that the earlier model had is actually fading away, and which also artists need to consider, that if they want to present themselves with all these new technologies and the infrastructure, they have to be equally professional and equally serious and equally careful about producing their content. Especially these days, I have seen with pandemic, it has added more complexity to the overall music distribution perspective, as because the live performances are not happening, and it is a need of an artist to be in front of people to keep on producing material. I've seen that artists are doing so many live shows, or going live on YouTube or Facebook and so on and so forth, without a good appropriate environment for producing that content. And so artists themselves are making themselves freely or easily accessible, which is in long run is going to hurt the artists themselves. Okay, so artists need to keep that in my mind as to what is their strategy needs to be for the short term and the long term, given the overall length and the overall environment and the things are happening around them. So for the short term gain of being in front of people, if they are going to hurt in the long run, artists really need to think twice whether they have to do what they are doing currently and just make them available so easily to people, and that too for free, right? So it artists have to consider all the rules of business, which also apply to the artistic expressions and artistic contents. Because if you make your product, for example, if you make your product available for free or for cheap, people would expect in the long run to have it available for free or for cheap in the long run. And at that point of time, artists will have a lot of difficulty uh, you know re restating or re-evaluating their value proposition. So I would really urge artists, especially from the business perspective, to look at those aspects. Next is very important is the artists need to understand, I'm talking from the business perspective and the entrepreneurial perspective, as their offering is a trade. Okay, whether we like it or not, whether we accept it or not, but ultimately when they are performing, when they are creating the content, and then they are producing promoting it or presenting it to the audience, it is a trade. Which what I mean by that is, you are giving something to get something, right? So you are showing, you are giving the presentation, you are giving the content to the audience, and against that you are you're getting the recognition and the remuneration and all the other paraphernalia or the free, frills that come along the performance, the name and the fame and so on and so forth. So if you consider that every transaction or every performance is a transaction, I may sound very, very dry or very, very factual maybe at this point of time, but I really feel that artist has to think their presentation as a product, because all those rules apply. And the transaction value, which what I mean by transaction value is the value of the ticket or value of the remuneration, or whatever the remuneration that they get is going to be directly proportional to the perceived value of the product they are going to offer. Right? When I say perceived value, you cannot really have a value for a present art presentation, because it is not like a trading where you buy something, you add your margin and then you sell for something, right? It is still a expression where you have to decide the perceived value based on the demand and the supply, right? So all these rules of business actually also apply for the musical presentation or artistic expression, so to say, in the normal world. There is always a remuneration dilemma in the minds of artists, whether how much should they quote as their remuneration, because there is, as I said, you cannot really have any value because there is no buying, there is no margin, there is no selling. So how do I make sure that whatever the price I'm quoting is right, if at all you are free to quote your price? Most of the time the upcoming artists are not even considered, or they are not even expected to quote their price, because traditionally the way I the way I have seen it, and the way I always explain it, that it is always a exploitation model. What I mean by that is, when the artist is not known, when artist is not really a popular artist, then the music companies or the producers um, exploit artists, because it is a one-way street. As Artita mentioned again in her speech, it's a one-way street. You are not supposed to challenge or question any terms or condition which is written in the contract, if at all there is a written contract. Okay, so everything happens on the word, everything happens on the as a gesture of obligation from the organizer or the producer of music towards the artist. So artist hardly has any say in stating its terms. So music companies exploit the artist. With luck, with over a period of time, artist becomes really a popular artist and he is really a sort of artist, and so on and so on and so forth. At that time the exploitation is the other way around. Means then artist starts quoting, मैं इतना लूंगा, मैं इतना ऐसे ही ट्रैवल करूंगा, मैं 5 स्टार में ही रहूंगा, मैं यही से करूंगा, मेरे साथ इतने सारे लोग आएंगे, इतने सारे शिष्य आएंगे, and so on and so forth. So what happens is, then music companies and the producer are at the mercy of the whims or these terms and conditions of the artist. So basically artist knows that now I'm in the driver's seat, so now it's my time to exploit the music companies the way I got exploited in my upcoming years. So this model is based on either the exploitation from either sides, or as they say, it's a oligopoly, which is restricted to very few players in the industry. So it doesn't have to be that. If you find a organizer, if you find a producer who is willing to work with the artist on a win-win basis, then it is possible. And I'm really happy to say that I have been trying through Sonic Octaves to have that win-win situation with the whoever artist that I have worked with, and it has been successful so far, because uh, for last 15 years I've never had a bad experience or a bad, even the bad conversation with artists related to all these aspects or the legalities or quote unquote the terms and conditions about it. When I say business, I mean business, what the entrepreneur is looking for. So it is for an entrepreneur to sell something in the artistic world. It needs to have some of the components up to the mark. One, good product, good marketing of the product, good advertisement of the product. By the way, marketing and advertisements are two different things. Marketing is building a brand, and advertising it letting people know about that brand. So marketing is good marketing, good advertisement, good delivery. So you have marketed a product well, you have promoted an artist well, but then artist has to actually come up to that expectation, to deliver the content that he's expected to deliver. So the artist has to take care from that perspective, that he is to deliver based on the marketing and the brand promotion, and the way people have helped him to get in front of people. So he has to live up to that expectation. And ultimately the good service, when I say good services, see, as with any other service offering, you go ahead with the person who you feel comfortable with, and person who treats you on an equitable basis. So even the artist, when they go in the concert hall, or they get into any contract, they have to realize that they are actually offering um, their services, and also they have to make sure that they are very uh, uh, collaborative with whoever they are working with. It cannot work based on as I said, the exploitation model. One thing that, hello, is there anything? Okay. Um, One thing, what I've realized is, what really sells, as with any other aspects of any other profession or any other product, is USP. Most of the times when I talk to the artist and we have our uh, counseling sessions, first question that I ask him is, there are about maybe more than 10,000 people who are doing exactly what you are trying to do in terms of the music presentation and the knowledge of rag and the voice and tayari and so on and so forth. How do you distinguish yourself from those other 9,999 people, so that I consider you, producing you or promoting you or recording you, over the other 9,999? I must say that very, very, very few people have this idea of what their USP. USP means the unique selling point is. So I think the artists need to think about, if they are considering this as a profession or as a business, then they need to think about what their unique offering to the audience is, because audience will give preference to people who have something really unique to offer. So this is a brainstorming, internal brainstorming, that artists need to do, in order to decide what is their USP, what do they bring on the table, so that people and the organizers and the producers are willing to work with them, because it's only them who offer that unique experience to the audience. So USP definitely does matter. uh, Customer delight or repeat customers, when I say that, see, I'm talking very businessy, I know that. And but it is very important for the artist also to think from this perspective, which is a entrepreneur's approach, considering the presentation as a product, as I said earlier. So when I say customer delight, if you go to concert, if you produce something, if you create a content, does it really please the customer? Do they really like it? How do you know that they have liked it? Do you have a feedback mechanism to know whether people have liked it? Do you have any ways to understand what aspects of your presentation went well, what aspects of the presentation did not go that well that you expected, the way it should happen? So do you have that way of getting the pulse of the audience? And what is important is, would this organizer call me again because I have been a good uh, delivery, or I have been a good musician, which helped him gain whatever he is expecting out of it? And if that happens, organizers will call you again, the producers will call you again, and you have more opportunities of presenting your art. But if you do not make your customers happy, your audience happy, your organizers happy, your producers happy, then it is very difficult for them to come back to you, because of, if they have had a bad experience, then it is very difficult for them to come back and say, hey, why don't we work together and create another album, or have another concert, or have another tour of yours? So it is very important to have that a very collegial and collaborative approach towards whoever is the entrepreneur or the businessman behind this. I already mentioned marketing is not just the promotion or an advertisement. It is a brand building. For an artist, this is very important to create his or her own brand. When I say brand, it is the experience that goes with the name, what is called as brand. So once I say, "Ki, okay, such artist is really good, or such and such artist is really the one I want to hire or one I want to work with because he's a good gentleman. He takes his profession really seriously. He is on time. He's not fussy with the terms and condition. He's very collaborative, but at the same time he's very straightforward about what his expectations are, and he's very considerate and fair in his dealings. If people talk about the artist in these terms and in this language, then there is a chance that they are actually building their brand. Okay, so it is very important for artists to know what kind of personal brand they are projecting to the outer world, because that is what is going to bring them the next opportunities. As I always say, it is not the art or it is not the skills that pays the artist, but it is the brand he creates with the art which ultimately makes him successful or pays him well. So it is not just the art. People are not just going to listen to music and then you will be a very successful artist, in my opinion. But it is the whole package of you projecting yourself as a personal brand, and then people recognizing that as a brand, and then the fame and the name and the concert and the recognition and the money follows. And we have seen this with so many very very successful musicians and artists around us, that they are very careful about their personal brand, the way they project. Okay, so that is very important. You will be surprised to see when I mentioned KYC is applicable to artistry. Know your customers. What I mean by that is, okay, for the type of art that you are producing, you need to understand who's your target audience. You cannot just have every person listen to you, because that is not going to be productive to you. So you need to really streamline what are the different things that we need to work and project and present, so that you actually cater to the right audience. And do not scatter yourself with the information. For example, I jokingly say sometimes that when I see artists using their Facebook in the way they are using, it is very funny to see sometimes that in the morning they post some picture of they going to some places and having a morning walk, and then in the afternoon they'll post, I've made this curry, and so this is the picture of this curry. In the evening they'll post some music, live music. In the night they will post something different. If we actually are not really focused on what we send out as a message or as a branding material, then people get distracted. They know that they don't know what kind of messages you are sending. So you are very important to use the social media in a way that will add to your personal brand. Okay, and it is very important, and catering and focus towards who your loyal customer is, who your loyal audience is. So that is very very important. Also, I think artists needs to really take the audience into consideration and consider them as the collaborators who are actually going to produce with them if they are in the live setup. So it is very important for them to know why you are doing something that you are doing. For example, if you do not allow the video recording um, during the concert or during the live concert, I think the artist should explain the reason behind the logic to the audience, saying that this is the art which we are doing it as a as our profession. So if you record, if you do a invalid or illegal recording, it is actually going to hurt us. And if it hurt us, you are not going to get another such good music to experience in the long run. So it is important for you to understand that we as artists also need to to be taken care of, and it is your responsibility to do so. So if you have that dialogue, such dialogue with the audience, I think most of the people in the audience will understand. And not only that, they will understand, they will appreciate your approach towards them, and most of them will comply to your request. So I think it is important to consider the audience as your collaborator. Again, all of this is because you want to think win-win, because everyone wants to win. Producer wants to make his money, artist wants his recognition and the money, audience wants the great experience. So everybody is looking for something in it, and if they get what they want without really making the other party lose, it is actually going to be the great value proposition for everyone. So how I evaluate the artist is, first of all, I evaluating a product which is artist or an art based on all these criteria. So when, if it is difficult for me to deal with an artist, in my first experience, i I will be very, very reluctant to work with the same artist for another project. Okay. uh, which also means that I will not be promoting on my own, even if the artist is of high caliber. So from the entrepreneur's perspective, my urge to the artist is they need to be very, very cordial and collaborative, and you know, they need to understand that the other person is also a human being. So they have their own restrictions, they have their own limitations. So they have to come on an equal platform and then have that very collegial or very open discussion about the terms. Evaluating the perceived value, how do I um, fix what is the right value, what is the right fee for the artist? Again, it depends on the demand supply, it depends on the USP, it depends on the circumstances, it depends on the genre, it depends on so many different aspects. So the artist also needs to understand this is what goes inside of the entrepreneur's mind, as to, in terms of the value that the perceived value that the artist brings on the table, if he is or she is getting enough remuneration or fair remuneration for whatever she or he offers on the table. So that is very important. Documenting the transaction details, we were talking about the contracts. I think what is important is to be uh, to have all the facts and all the aspects of the transaction on paper. What I mean by that is roles and responsibilities of the buyer, in this case the entrepreneur or the producer or the organizer, and the roles and responsibilities of the seller, which is in this case is an artist. So as what we heard in Chaitanya ji's presentation as well as Arati ji's presentation, what if the concert is cancelled? What if the artists are not available? What if the visa gets cancelled? All those things, possibilities based on your previous experience or based on the experience of the other artists, need to be talked and discussed and documented, so that as I mentioned in the next point, it is better to be upfront. It is better to have all the points cleared out earlier than to confront later. I repeat again, it is better to be upfront earlier than to confront later. Okay. So if everything is written, if it is agreed, it is stated in black and white, signed by both the parties, then what generally goes wrong is misinterpretations of this. Oh, I thought you meant this. Oh, I thought you meant that. Or misreporting, as again Artiji mentioned, she did not get any reports about how much the records were sold, how much of the business was, and so on and so forth, because she was a part of, or she actually was a party to that exploitation model from the company's perspective at that point of time. So companies did not really feel the obligation to share that data or report the right data to the artist, because there is nobody, or there is no way anybody can challenge the data that they produce. So it is the responsibility of an entrepreneur or the producer or the business person to actually do the right reporting to the artist, because it is not only fair, it is morally required for the entrepreneur or the business people to share. Because if they have agreed to a certain amount of royalty, if they have agreed to certain amount of payment to the artist, they already know the facts. They already know that if the album does well, this is what their risk is. If the album doesn't do well, this is what the risk is, and also the rewards which goes with that. So if they are very honest about the reporting, then, and if they take the artist in consideration, and in faith and in trust, then artist also understands that sometimes things may go as per the expectations, or sometimes they may not. But that dialogue, that understanding, that trust is what is very important. And the third part why things go wrong is the mischief, कि मैंने ये रिकॉर्ड कर लिया, लेकिन वही कुछ बात मैंने दूसरी जगह से किया, फिर वही बात मैंने तीसरी जगह से किया, and then I've made 3 different contracts with 3 different people for the same content. I'm just giving example. So this is kind of a mischief, or also from the mischief from the entrepreneur's perspective. Yeah, मैंने बोला मैं आपके 4 album करूंगा, लेकिन I just did 1 album, and I contracted you for 3 years, but then I did not promote you. So all these kinds of things people do for a very particularly when it comes to the commercial aspect. And one thing I've noticed, and one thing I've observed, is everything is hanky dory, everything is really good when things are not going well, or they are to be done later. So every when at the time of contract, हाँ वो कर लेंगे, हाँ वो कुछ problem नहीं, हाँ ये वो ठीक है, there is no problem, अरे हाँ यार हम लोग record कर लेंगे फिर बाद में देख लेंगे. All these things come into picture, right? People just ignore, they just say ki, okay, things are taken for granted. But if the record is hit, if it is popular, it starts making money, if things start going well, that is when things start going wrong in my observation. And that is where the contract or the paper in place comes into picture, and the understanding and the trust that the artist and the producer has in between them. So when things start going well, that is where the artist and the entrepreneur have to be very clear, they have to be very honest to each other, very open to each other, and share whatever the information is, because entrepreneur knows that artist has that due from the success that it has brought to them, to both of them. So in my opinion, trust is the name of the game, and is the name of the fair game. So you have to trust people, you have to just feel that people are out there to help each other to progress, to succeed basically. So that point of trust is also very important. One thing we need to be very clear here, and artist and both artist and the entrepreneur needs to understand, is the risks and the rewards should be proportional, and especially the financial risks being more prominent. So whoever is taking the financial risk has to be rewarded financially more. Okay. For example, if the artist is, sorry, if the entrepreneur is doing all the expenses for recording an artist, promoting an artist, advertisement, distribution, and everything, it is absolutely fair to give him much more or bigger portion of the pie, or the bigger portion of the remuneration, than to the artist, because the risk, the financial risk taken by the entrepreneur is much more. Although artist is the key, is the reason why they are producing that content, but sometimes artists बोलते हैं, अरे हमारे आर्ट के वजह से तो इतना बिजनेस हो रहा है, अरे यार हमारे कला के वजह से तो इतना बिजनेस हो रहा है. And that is true in a way, but then who's taking the financial risk? And that is why who should be given the financial rewards also. And that is something that artist and entrepreneur both need to understand. The risk and reward, especially when it comes to financial investments, have to be proportional. Okay. Another very interesting aspect of this whole law and music is the audience perspective. For audience, for some reason, especially in India, maybe outside also, but especially in India, piracy is okay for the artist or for the audience, which in my opinion is very interesting, because I hear people boasting about the facts about the gigabytes of data that they have with them, which is pirated. अरे तेरे को मालूम है, मुझे आमिर खान साहब का ऑलमोस्ट 200 GB का मेरे पास कॉन्सर्ट है. अरे मेरे पास विलायत खान साहब के 3 GB का डेटा है. अरे मेरे पास इसका 5 GB का डेटा है. In total, I have the classical collection about 20, 30, 50, 100 GB of data, and they boast about it, which is a bad part. They don't realize, the audience doesn't realize that doing the piracy is actually going to hurt the artist, which is hurting the artist in the long run, and they are going to be deprived of good music later because the artist cannot survive if there is rampant piracy. Okay, so whoever is here in this audience, they may feel upset or bad about it, but whoever boasts about having that huge amount of musical, अरे मेरे पास 1000 गाने हैं, अरे मेरे पास इतना सारा डेटा है, अरे मेरे पास ये आर्टिस्ट का इतना ही कॉन्सर्ट्स है, I think it is bad. Okay, it is bad to copy things, it is bad to give the, अरे मैं तुझे दे देता हूँ, मेरे पास 20 GB का डेटा है, तू पेन ड्राइव लेके आ, I'll give, copy it and give it to you. That is hurting music. So people in the audience who probably are doing that, I hope they are not, but if they are doing that, I would urge them and request them to stop doing that and be aware that they are not doing the right thing. They are actually hurting the artist. Okay, from the from the audience perspective, artist is not supposed to be commercially oriented. So if the artist says, okay, please don't record the concert, तो the audience says, उनको क्या जाता है, हम लोग सुनने के लिए आए, हम लोग ने टिकट दिया है, हम लोग ने पैसा दिया है, तो हम लोग रिकॉर्ड करेंगे, तो आर्टिस्ट को क्या जाता है, ये बहुत रूड बंदा है. No, that is actually hurting the artist, as I said. So if the artist or anybody in the audience is doing so, you don't need somebody's disciples to watch them, right? You need to be very aware as an audience, and a responsibility as the audience, to make sure that nobody around you is recording, or report him to the organizer if he is recording illegally. So it becomes your responsibility as a part of the stakeholder in this whole ecology to be aware of such things and refrain people who are doing this piracy from doing it. Okay, also need to audience need to understand the remuneration for the time of the concert is not just for the time spent during the concert, but it is the time and the energy and the dedication of all those years and of practice and sadhana that artist has done. अरे यार वो 2 घंटे के लिए इतना लेता है यार, 2 घंटे के लिए इतना बहुत ज्यादा हो गया. That's the comment which actually you are disrespecting artist sadhana. Right, so from the audience perspective, you have to be aware that in order to perform for 2 hours, that artist has spent 20 years preparing for it. So audience in general needs to really have that perspective and respect towards the artist and its time. It's not just the concert time, but all that time that he has spent sacrificing some of the pleasures during the course of time, and that is something that we really need to understand. Coming to my, I am just 5 minutes away, I know. I'm on almost on the last slide. So nexus between law and music, entrepreneur's perspective, this is the crux of it. One is reputation is everything. Whether it is the reputation of the organizer, whether it's a reputation of the entrepreneur or the producer or the record label, or it's a reputation of artist. It is built over a period of time, right? So as you build your reputation, you will grow the opportunities to do better and more business, more morally and legally bound business with the other artist in a collaborative manner. And one thing, if you go wrong for some amount of money or whatever the reason is, it takes, as they say, it takes years to build the reputation, but it takes moments to destroy it. So I think the crux of this whole discussion is to have that reputation of being a very fair, positive and upfront uh, stakeholder in this whole ecology. To do that, please get and state the facts straight and put it in on a paper as a contract. And it has to be, when things are great, contracts have to be really explicit and very, very open and very detailed, because when things start going well, that is where the things or the problems start. So we have to consider all the positive negatives aspects of it, and also the timelines and the time frame in which that particular contract is to be exercised. Thirdly, it is okay to negotiate, and also it is okay to say no when you are not in comfort zone. If there are certain terms and conditions which artist feels are not in are not comfortable for them, it is okay to say no, because there will be more opportunities later. But if you get into a contract which is not as per what you are expecting, then there is a potential of you getting into more trouble later because you got into that contract. So in that case, it is just okay to say that, you know what, I'm not comfortable with this particular term. So either we change it, or no, I'm not really interested, I'm not comfortable getting into this contract. It is okay to say that. And it it may send a small message of rudeness, quote unquote, from the artist perspective, but it will avoid all the confrontation later, is what my experience is. And it really helps to be very, very how to say, very comfortable about what you are getting into. Following through the commitment, especially commercial, is important, especially from the entrepreneur's perspective. Because I remember when we got into this contract and I offered the royalty in the first year to the upcoming artist or whoever the artist that I was working with, they were really surprised ki there is some music companies who is actually calling uh, initiating the call of saying that, oh no, we owe you royalty, and where do I and how do I transfer it to you? Okay, it was okay for some of the artists to do it on the first year, but when second year I called them, they were even more surprised, that say, even second year you are giving me the royalty? And I said yes, because that is what the obligation is, and that is what our commitment is. So if your music has earned something for us, it is our responsibility to give you the part of it what we discussed. Although very interesting point is, in some of the projects that we actually had lost money recording an artist or promoting an artist or producing him, we actually had lost money. But even despite of that, we felt that it was our moral responsibility to, whatever the remuneration or whatever the revenue that we generated out of that person, we were morally obligated to give that portion to the artist, because we took the risk. So we also need to take that impact on us. It is not the artist who should be the part of it, because it was not stated um, in the contract. When third year I called them and said, hey, your royalty is due, they were really, really surprised. Is they're saying it is like a miracle that some music company is actually calling on the 3 years consecutively to whatever the amount is. The amount is not important in my opinion. What is important is that commitment towards following through the commercial contract or commercial commitment that both the parties have agreed to, and that is what builds that trust, that is what builds that community, that what builds that lasting relationship, as I said, and which is the key. If we get into legal battle, it is actually a lose-lose proposition. So it is better to be upfront, and if something goes wrong, it is better to sit across each other and sort things out rather than going to the court, because people do know what is fair, right? We just have to come to that agreement that this is the fair arrangement and let's work on it. Because going to court, fighting a legal battle, is actually a lose-lose proposition for all stakeholders, basically. Because in terms of, if you count time, energy and everything, that is like a lose-lose proposition. As Chaitanya ji mentioned, it is now important, very important, to have the artist guilds, especially for Indian classical musicians, and have that kind of infrastructure and the societal pressure points for people who are taking advantage of this overall ecology of music. And music guilds or musician guilds or artist guilds do have such pressure points on such people, and which are experienced in the Bollywood music. They have producers guild and composers guilds and musicians guilds, and they do have the mechanism to put that pressure on the person who is not doing the right thing. So I think, especially in the case of Indian classical music, those artist guilds have to be really strengthened and supported by the community and organizers, and there has to be a consortium. And I think some symposiums like this will enable the initiation of forming such uh, entities, so to say, so that we can have a, like a moral police, as they say, watching over all these transactions. And last, and but not the least, I believe personally that believe and follow the law of karma while following the law of state. I think this is the crux of the whole thing, that whether you believe it or not, whether you think it is applicable or not, I have experienced personally in my life that law of karma is very strong. If you do something right, things work really well for you, and if you do something wrong, they will come back and haunt you one way or the other, at if not now, later. So it is always better. Definitely we have to be we have to follow the law of the state, but what is more important, man, in my opinion, even as a business person or as an artist or as like a part of or the stakeholder of this ecology, is the law of karma. You do right things, you do good things, and you will be blessed, you will be uh, given the success and the name and the fame that you're expecting. So that is what I think the whole um, crux of what I wanted to say, and I hope I was uh, clear enough and mm, descriptive enough in order to mention or put
Obviously.
forward my thoughts. Thank you so much.
Obviously. So I really thank you, sir, for sparing your valuable time and the aspects, the opinions, and the views which you have shared from your point of view, that entrepreneur's point of view. Those are very much important, as because always the people, being the audience and the artist, being the main performer of that may be an album, that may be any concert. So everyone is thinking from their point of view, but at some point of time they are not able to understand the point of view of the organizer, the point of view of the entrepreneur, as a, we can say that the funding part of that particular aspect is concerned. So it was really the enriching kind of a experience for all of the participants and all of the students of law and students of music to understand all of these minute details regarding any entrepreneur. So thank you so much for sparing your valuable time and participating in this particular symposium and trying to connect. So you have done a very fabulous job as to connecting both of these disciplines, that is law and music. Thank you so much again.
Thank you
Sir.
so much. I just have I
Yeah.
see some questions in the chat
Yes.
box. Are we do we have time to
Yeah.
take those, or we can
Yes,
just
sir. You can
pass
take
them
the
on?
questions.
Okay,
For sure.
so
For sure.
this
So,
says, good afternoon, sir. I have Vibhuti Mishra. It says, I have a question
yeah.
to you, sir. As we see, it is an era where the low fidelity versions, reprised versions, remixes, and covers are also are so called very trendy, and people create their own versions
Yeah.
out of the original pieces, which eventually get more fame. So I want to ask, is there any clause present
Laws.
which restricts such compositions? If not, then who may or may not use the original content? Who will take care of these things? I think this is more specific to the IP law. Um, and in my
Yeah.
opinion, from the content perspective, there is a trend for the covers, but let me tell you, those are very short lived, right? If you create your original content, it may take longer for people to recognize, but it will be much more remunerating for the artists to create their own content. One, there is no IP issue, and two, that is what will, you know, build their brand. Because if you do covers, and as you said, the lowered version of the original content, that is very short lived. I don't think that fame, if you want such kind of fame, it's a different story, but that's not long lasting, is what I feel. um, there are some people have said that please can presenters use English. Certain I must say that certain connotations or quotes are to be mentioned in Hindi, because that is how
Yeah.
things go
And
around, and that's why I had mentioned Hindi. So I'm sorry if it is not clear to you, but
no,
that
no.
was the need of
Don't be sorry, sir.
yes.
I've shared the same opinion and
Yeah.
same review with the
Okay.
participants. So
Okay, great. So I don't
yeah,
think there are
yeah,
any
yes,
other questions, I guess.
yes, yes. So I request all the participants to kindly fill up the feedback form, and the link for the feedback form I have shared in the chat box. So please fill up the feedback form. And about the next session, that is by Advocate Amit Datta. So I feel very sorry to share with all of you that just today morning, Advocate Amit Datta, he has tested positive, COVID positive, and he is not able to join us today and tomorrow for this 2-day National Symposium on Lawn Music. So, so now we are taking the break of half an hour, and we will join by 1:30 p.m. for the next session by Professor Adam Dubin, and he will be talking on very innovative approach, the social approach of the music and the law. And he joining from the Spain. So we'll be meeting soon on 1:30 p.m. Okay. So yes. So I would like to request all the participants to join around 1:25 p.m. so that we can start with the session by 1:30 p.m. Thank you.
नहीं मेरा ब्रत है